And we finished off with number 27 on the confirmations. And so, Senator Respicio.
Thank you very much,
confirmation.
Madam Speaker. Madam Speaker, item 28 on the legislative concurrence is from the Senator Rodriguez's Committee on Health and Human Services, Senior Citizens, Economic Development, Election Reform, on the appointment of Dr. Aurelio Espinola to serve as a member of the Guam Board of Medical Examiners with his committee's recommendation to confirm. I move that be placed in the voting file.
On the motion without any objections, so ordered. Okay, thank you. So,
And Madam Speaker, we're now in the second reading file, and the author of Bill 8-31 has been advised that her bill is the first on that agenda.
no, so we're going to go ahead and go into bill number 12-31.
Same author, so
Same
we probably
author.
proceed to resolution 12-31. And if it's okay, Madam Speaker, we go back to items 1 and 2 when the sponsor.
Yes, as soon as the sponsor returns. I recognize the author, Senator Pangilinan, on resolution 12-31.
Thank you very much, and Sijus Masi, Madam Speaker. Madam Speaker, I'd like to move that resolution 12-31 COR, relative to expressing the sense of the Legislature in Guam's expenditure priority of compact impact funds for fiscal year 2010 to Imagalahin Guahan and to the Secretary of Interior to support capital improvement projects and operations of the various impacted government agencies and departments. To the third reading file, I'd like to speak on the motion, Madam Speaker.
Yes, you may proceed.
Thank you very much, Madam Speaker. Madam Speaker, Bill number 12 is as I just read in the title, really is a articulation of the priorities that the legislature wishes to make known to, of course, the Magalahin Guahan and the Secretary of Interior on what would be appropriate expenditure of compact impact funds as awarded to Guam under the U.S. law that was passed, which granted Guam and the other affected territories and states some financial relief from taking care of the compact impact habitual residents that reside in the different jurisdictions. The resolution actually would divide the roughly $16 million that the government of Guam receives every fiscal year into the departments and agencies that we have found in the review of the budget over the last couple of terms, as well, where we've handled the budget, the Office of Finance and Budget, as well as over the last several years when the budgets have been passed and the priorities have been come down from the administration. We get about $16,850,000 a year, and this is the total amount that is made available at this time. This is by no means what is actually expended by the government of Guam. I want to make that clear and repeat it again, is that the $16,850,000 is what the federal government pays to the government of Guam, but it is in no way reflective of the actual amounts and costs incurred by the government of Guam in providing services to the compact impact residents. When I say that, I also want to say that these compact impact residents, just like any other community on Guam, contribute to the financial resources of this government of Guam when they are gainfully employed, when they actually participate in the commerce of the community and our island. So while there is a cost, they also contribute to our island government. But just as any other community, there are direct costs that can be identified that we provide. And we have looked at the areas where we thought would be best suited for the expenditure of this funds based upon really a compilation of the past expenditures of this fund. We look at the areas of public health, public safety, and public education. And so the bill would make it known to the Secretary of Interior, which approves the expenditure of these funds based upon a request submitted by the governor. Now, over the years, we've had many conversations with federal officials, as well as our Washington delegates, who have worked with the compact issue in Washington, and of course with the Secretary of Interior and the Assistant Secretary of Interior, more specifically, in the expenditure of these funds. When the Assistant Secretary of Interior was on Guam recently, we had an opportunity to meet with him to discuss the priorities of the legislature in the expenditure of these funds. And we wanted to inform him of the sense of where we think these funds should be applied. And in the past, it's always been the governor that makes the application, and the legislature's kind of left out of it. And over the years, we've kind of grappled with how do we, as a legislative body, who's responsible for providing the resources to the departments and agencies for service to all of our communities, including the Compact Impact residents, can articulate where these funds may have the best impact for our citizens and our community. And so we developed this list to present to the Secretary of Interior so that he can have an idea of the priorities of this body. Now, the largest chunk of the money is already spoken for, in that the governor in the previous administration had, through obligation of these funds through the Build, Operate, to Own program for construction of schools, have obligated about $7.1 million of the $16 million for the debt service on these schools. So we are keeping with that priority because that is an ongoing obligation of this government. And this, of course, goes towards the Department of Education for the school facilities that we've built. And these are Okudu, Adakau, the four new schools that have been built. Liguan, and I think Machinana was part of Astumbo. Astumbo would be the other school. So $7.1 million is dedicated to paying for the debt service on this school. Now, we would also like to prioritize $5 million of the remaining balance of that from the $16.8 million, $5 million to go to GMH for the pharmaceutical supplies at the Guam Memorial Hospital. We know, and it's one of the issues we're dealing with in trying to ensure that the hospital gets the support it needs from the general fund. And so this is something that has traditionally been done, and we just wanted to once again articulate that $5 million of this remaining balance would be dedicated to GMH for pharmaceutical supplies. And $1 million would be to go, again, to health services at the community health centers. The Guam Community Health Centers was able to avail itself of ARA funding to hire some public health service doctors and staff to expand the community health centers. A lot of our Compact Impact residents access that public health service facility for their medical care. And the ARA funding is going to expire at the end of this fiscal year. And so we have about, I think, a couple of physicians at the public health centers in which their funding for their salaries would expire from the ARA funding at the end of the fiscal year. And so we have articulated once again that $1 million of the Compact Impact would go to the public health centers for the payment and the continuation of the service of the nurses and the doctors at the and additional pharmaceutical supplies at the Guam Community Health Centers. We also looked at the Guam Police Department. Now, the Guam Police Department is in the process of moving its headquarters because they may need to vacate that facility that they're in because of construction plans at the Guam Airport Authority, and they may need to relocate. And one of the challenges we have in terms of the budget is finding the cash to support the additional rent that they would have to pay should they move someplace else. And the area they're looking at is the customs building, former customs building in Tijan as part of their headquarters facility. And if we look at the current budget and the revenue structure, we're going to be hard challenged to find the additional resources. So we've earmarked $750,000 for either the construction of additional facilities or that lease for that new area there. So once again, this is a area of public health that we think that the Compact Impact Funds would be appropriate to support. The other support on the public safety and public health side is the additional ambulances that would be purchased, and we're earmarking $750,000 of that to purchase additional ambulances for the Guam Fire Department from the 2012 Compact Impact grant. And the remaining balance would be divided in this manner. $750,000 for the lease or the purchase of new transactional database for tracking child support payments. We have been trying to work with the Attorney General's office to provide them seed money for their child support system. They have an outdated program. We provided them money for an analysis of their existing system and what kind of system they would buy. And we are earmarking $750,000 towards the beginning of transition towards the acquisition of that new child support system. It's something that we need to do that we're, again, have been struggling to find resources for. And then $1 million of the remaining balance would be for the Guam Mental Health Substance Abuse amended permanent injunction. We have a schedule of payments that we have to make, and this is would help the general fund support that payment for mental health services to its clients under the amended permanent injunction. And then the remaining balance of $500,000 would be available to the Department of Administration for some efficiencies in their point-of-sale system for payment of taxes and fees at the Department of Administration. This would continue the automation that is ongoing at Department of Administration. We're transitioning from a government-based cost for the acceptance of the payment of credit cards to a user-based fee, convenience fee for that, and the point-of-sale system is integrated to the credit card payment receipt system, and so this would appropriate money for that. Madam Speaker, it's a sense of the priorities that this body would feel is appropriate for that. There are many, many challenges and many requirements, and we could put these monies in many different fashion and many different places. But we have tried to the best of our ability in the examination of previous budgets, previous allocation of these resources to stay within the confines of public health, public safety, public education, and trying to also find resources to support the departments and agencies providing these services to the general community as well as the Compact Impact community. And so I ask my colleagues, as we develop the budget, this all can change in the final budget document depending on what the governor submits and depending on what the Secretary of Interior will approve. But it is our articulation of what we think would be appropriate expenditure of these funds and making the governor know in our attempt to work together on this that if we can merge what he wants the money for, what this body is, and we try to then take this resolution, take what the governor will submit in his budget, and we'll mesh it all up in the final budgets that is planned. But we felt that this would be a good guide for the Secretary of Interior, for the governor to consider in developing the final expenditure of these funds for approval by the Assistant Secretary of Interior. So I ask my colleagues for their support, Madam Speaker. Thank you very much.
Thank you, Senator Pangilinan. On the motion on Resolution 12-31? No one? Okay, that's on the motion then to send Resolution 12-31 to third reading file without any objections, and so ordered. Senator Guthertz, you're recognized on substitute bill number 8-31 LS.
Yes, thank you very much, Madam Speaker and colleagues. Good afternoon. Madam Speaker, Bill 8-31 would provide the Department of Education with a management tool to determine what works best for them with respect to providing maintenance and custodial janitorial services at our public schools.
Motion to accept.
I'd like to move that we accept Bill 8 for discussion purposes and
may
move it down
continue.
to third reading.
Okay, but you want to continue.
And I would like to
speak?
continue
Okay.
speaking on it.
Yes, please
Thank you.
continue.
Thank you. This measure, Madam Speaker, just for clarification, in no way directs, or for that matter, requires the Department of Education to take on the responsibility of providing its own services in the area of janitorial services or maintenance services or custodial services. But it gives the department the authority to do that if it feels it can justify it for efficiency purposes and cost purposes, and if it meets the needs of the school system or some of the schools in the school system. All of us know that the DOE management team strives daily to meet the needs of our school children and to address the various demands on the upkeep of our public school facilities. Just like any home, things break and require repairs. Spills occur in cafeteria that require immediate cleanups. Problems happen in our school facilities. They are very old. The infrastructure is very old. And they have to be maintained quickly and on a continuous basis. It simply makes sense to authorize the department to determine what model works best for the organization as a whole, or in certain cases on individual school bases. It is more advantageous for the education department to maybe hire in-house and provide its own custodial or janitorial workers versus utilizing privatized contracts. This is a question that many people ask. As you know, the Department of Education has had several years to gauge the workings of privatized services, which were mandated by law, versus in-house services. And they should be able to have a basis for comparison. Our school children shouldn't have to wait for a lengthy process to have an air conditioner repaired or a toilet fixed that's leaking, or to have a cleanup need addressed in a timely manner. In-house services, in many cases, can respond immediately to the everyday needs at the schools and deal with these issues as they arise, and not worry about contract limitations or times of day limitations that impact contracts. at the end of the day, it's important to know which model is actually more efficient and more supportive towards DOE's needs and the needs of our island school children. Some of you may recall that prior legislation via Public Law 27-05 and 27-32 set a moratorium on hiring in the Facilities Maintenance Division of DOE and also in the cafeterias at DOE, and effectively set a sunset provision on the Facilities Division of DOE and the Cafeteria Division in the hiring of any new maintenance, custodial, janitorial, or cafeteria workers in favor of what was at that time called, quote unquote, the full privatization goal, unquote. The recent revamp of our education board through Public Law 30-183 repealed any and all restrictions. In fact, it makes no mention of any restriction at all on hiring at the Department of Education. However, it's very interesting to note that apparently our education department was conditioned with all the information and hoopla of the past of the benefits of total outsourcing services, that the management at DOE and the board to this very day believe that they do not have the authority to run their department as best they see fit in the interests of the school children of Guam. They're still under the impression that they are prohibited from being able to provide in-house services where appropriate and justified. Bill 8-31, with the simple language presented, added to the section of the code, states as item 13, with the concurrence of the board and subject to the availability of funds, have the authority to hire maintenance and custodial janitorial personnel. So it gives the department truly the option, if they think it's useful, to do so. This permissive language makes it clear and takes away any potential doubt and leaves the decision solely to the education department, where it should be. The rank and file of DOE, those behind the scenes in the Facilities and Maintenance Division of our public school system, know better, care just as much, if not more, and want to be able to help determine the success of the upkeep of our school system and its facilities. Right now, their hands are tied. At least they think their hands are tied. If the DOE management team or others in the future determines that having an on-site, at-the-ready, in-house team capability is more advantageous for a particular school than a privatized contract, then the superintendent should be able to manage necessary funding and provide those services as required. If passed, this measure will make it very, very clear that the superintendent would have this authority. And if passed, it would take effect upon enactment. Now, Madam Chair, if I may, I have one slight amendment I'd like to make to the bill.
Yes, Senator Guthrie.
Thank you. And I've passed it out already. It's very simple. Basically, in Section 1, the language in Section 1 would be revised to say, quote, have the authority to hire maintenance, custodial / janitorial, and cafeteria personnel, unquote. The additional word is cafeteria personnel, because the same logic should apply if DOE feels it's more prudent and efficient in some cases to have in-house capability to do repairs, then they should also have that discretion when it comes to the services they provide, the food services they provide to the children of Guam. So I make that one-word change in Section 1 to include the word cafeteria. And by the way, Madam Chair, as you know, we did have another bill with respect to this. It's almost the same as this bill, Bill 7, that dealt with cafeterias at DOE, to give the DOE department that option where if it feels it makes sense to have an in-house capability to offer cafeteria food, then they should be able to do it. So that's the amendment, Madam Chair. Madam Speaker.
The amendment is on line 6 after the word janitorial, add the two words and cafeteria.
Correct.
Then it'll be personnel.
Thank you,
And
Madam.
that would also be, that should also go with the title as well.
Thank you, Madam Speaker. Yes.
Okay, on the amendment, are there any speakers? There being none, are there any objections? No objections, so ordered. Anyone would like to speak on the amendment? On the motion then, on the motion rather, of Bill 8-31? There being none, so on the motion to send it down for third reading without objection, so ordered. Senator Guthridge, you're also recognized for Bill number 12-31.
Yes, thank you very much, Madam Speaker and colleagues. Bill 12-31,
12-31, yes.
yes, is an act, and I'd like to move, if I may, the bill down to third reading. I'd like to be able to discuss it.
Okay, please
Thank you, Madam
proceed.
Speaker. Bill 12-31 is an act to amend sections 5601G, Part A of Article 11, Chapter 5 of Title 5, Guam Code Annotated, to further define and expand its definition relative to the Public Official Financial Disclosure Act. There was a public hearing on this bill on February 17th, and as you know, Madam Chair, in the last legislature, I served as chair of the Ethics Committee of the legislature. And as an individual and also as a member of this legislature, I believe in full disclosure in government dealings. It is important to ensure the public trust by being open and transparent. This is an expectation of the public, an expectation of ourselves. This is critical in government and ensures the proper and fair operations of public services. Bill 12-31 will help to accomplish this goal of transparency. The measure would tighten up disclosure laws and further screen familiar ties in all procurement actions by the government of Guam and its officials. The measure would disclose family ties to the first degree, inclusive of in-laws. The legislation also encompasses familiar disclosure of a minimum of 3 generations and expands to adopted and step members of individual families. Full disclosure would illustrate procurement actions are on the up and up in this government. Broadening the specific provision of the Ethics and Public Contracting section of the Guam Procurement Law, which is what this bill does, is critical to diminish any undue influence in government spending. As well, we need to close any technical loopholes, and apparently there are many, in order to promote credibility in government. The people of Guam need to know and trust that public officials are judicious with expenditures and do not engage in personal deals by virtue of their positions. Bill 12-31 comes after my colleagues unanimously supported a prior call for more public accountability by persons who enter into contracts on behalf of the people of Guam. And this was through Public Law 30-79. This measure and Public Law 30-79 will help to reveal and discourage any favored treatment when it comes to procurement in this government based on family relations. Now, the language of the bill is very simple, Madam Speaker. The language simply would further define and expand the definition as follows. Immediate family, the definition would be, means a spouse, children, parents, brothers, and sisters, and that's the current language of the law, the procurement law. And this would be added, and grandparents and grandchildren, mother-in-law and father-in-law, brothers-in-law and sisters-in-law, daughters-in-law and sons-in-law. Adopted and step members shall also be regarded as immediate family. And I'm sure you can see this does close the loopholes that we have seen exploited over the years, some quite vividly on the front pages of the newspapers. We had one case last year regarding the Census Bureau. Remember the Guam Census Office? Involving daughters-in-law and sons-in-law and sisters-in-law and grandchildren, et cetera, et cetera. So I think you understand the intent, my colleagues, and if we're really serious about transparency, then let's make sure we do it right. I hope you will support this, this bill. Thank you, Madam Speaker.
You're welcome, Senator Gutherz. On the motion, Senator Toniata, you're recognized.
Thank you, Madam Speaker. Madam Speaker, this bill would require that all public officials to disclose personal conflicts of interest and the conflicts of interest of their relatives. My question, if the author would yield.
Senator Gutherz, do you yield to a question?
That's great.
You may please ask your question.
How do public officials compel or force their relatives to disclose what they own? I mean, reasonably, a person can deem to have knowledge of what his or her spouse and their minor children, but how can public officials be held responsible for disclosing what private adults' relatives own?
Well, I think if you, are you familiar, Madam Speaker, with the procurement law of the government of Guam, particularly the ethics and procurement provisions? I'd ask that question of my colleague, through you, because that spells out how this process is supposed to work. It's a matter of disclosure. If you are in any way involved in any procurement process, and there is direct involvement or indirect involvement of immediate family members, then you have an obligation to disclose that. And that's what this bill does. It requires a disclosure. Now, if it is a real conflict of interest, then there's another provision within the ethics of government law that states that you are not to participate in any of these actions that involve family members.
Thank you, Senators. You still have the floor, Senator Toniata.
Thank you, Madam Speaker. I just, it just comes to me because, I mean, we all like to, we all engage in business in one way or another. But to know what my brother-in-law has as his business assets, I mean, that really is none of my business. I mean, we're going now to adopted and step members. I mean, I know there's family members that have half brothers and half sisters, and they don't even know who they are, or they don't know what they do in life. And I think for us to keep expanding, I think the definition of immediate family says it all: the spouse, children, parents, brothers, and sisters. I believe that says all as an immediate family member, to where any conflicts of interest may exist.
Senator, you will get an opportunity also to speak at closing, please.
Thank you, Madam Speaker.
Senator Tina Muñoz-Barnes, you said you had a question?
Madam Speaker, Thank you very much. As joked about by my colleague from Magana Heights is saying that Senator Munya Barnes has a lot of relatives. That is indeed a very, very true statement. As you yourself said, are you related to the whole island? And probably in one way or another, there's a connection. There's even probably a blood lineage, but more importantly, so when you include step or reared and all that, I must be related to literally more than half of the people on this island, and I'm not ashamed of saying that. But I do have a concern, Madam Speaker, and my concern is that this act to amend this section, which is 5601G, Part A of Article 11, Chapter 5 of Title 5, GCA, to further define and expand its definitions relative to the Public Official Financial Disclosure Act. My question to the author, if I may, is if the definitions to include all these underlined individuals, which is grandparents, grandchildren, mother and father-in-law, brother-in-law, sister-in-law, daughter-in-law, and sons-in-law, adopted and step-member also be regarded as immediate family, will that individual applying for whatever it is, a bid or I would assume it's for the bid, right? For the bid process?
Under procurement laws, yes.
Would those in-laws, even those who are not here on the island, have to be disclosed?
Senator, do you yield to the question, Senator
Well,
Gatto?
I'd be very happy to clarify. This refers to those situations where you have a direct decision-making participation. If you are the director of a department or agency and you're in the process of procurement, and the individuals that are participating in the procurement are your direct relatives, you have to disclose that, yes.
You know, Madam Speaker, as I hear that statement, I honestly will share a concern with you, because even as I have a lot of siblings, in as far as actual blood-related siblings, there's 9 of us. And if you talk about my reared brothers and sisters from Micronesia, there's probably about 20 of us. And then if you include those who've lived in our house for more than 20 years, you can probably add another 5 to 15 to that, depending on what that definition is on staying in the household. And I would share with you that even as close as I am to my immediate siblings, the actual knowledge of what I know of what my immediate sister or my immediate brother is doing right now, and as far as business or as any relations, I am not familiar with. I will note for the record and disclose for the record that I do have family members on this island, immediate family members, so I think my own sister and my own brothers who have separate businesses, who probably have relationships with the government of Guam, that I myself today don't even know about it, because I'm not a part in any part of the association or the business that my sibling owns. And I'll disclose, for an example, on the record, I have a sister who owns an insurance company, and I know a couple of my colleagues who have immediate family members who own businesses, and I've insured by my siblings' company. I have part of my own personal insurance housed in that company, but I have no inclination. I know no business dealings, even with my own twin sister that probably has the business and all that. And I just don't think it's fair and right for us to include this provision. I mean, I don't know. I really have concerns. Please don't get me wrong, Madam Speaker. I have no problem with accountability and transparency. But if you're going to open this to this arena, I really think that the government is really, I don't know, expanding its definition in the wrong. The pure mission of this was to provide for the accountability and transparency and making sure that those people of providing for that bid there's no potential conflict of interest there for that individual applying. But for me to disclose what my immediate family does, I don't even know what they own to begin with. Not because I don't want to know it, is because, frankly, what the previous speaker from Sinanja said, that's not my prerogative to know. If they want to share it with me, that's fine. But I don't know. For me, this item of extending this kind of definition, I mean, I don't know, maybe if it was for extending, for assistance and helping out, maybe I'd support the efforts, but who am I to ask anybody else if I knew somebody who was applying for a bid or to try and win a bid, that they would have to disclose everybody else's personal personal finances? I think it's a detriment to that. There's no way, there's no correlation to that. Madam Speaker, I just stand not in support, but maybe in grave concern to this provision of the inclusion on this bill. So thank you for letting me voice that concern, Madam Speaker.
On the motion, are there any other speakers? There being none. So before, I want to make sure, Senator Blanche, you have a half-raised hand? Okay.
Madam Speaker,
You want to speak right
Thank
after
you
your
for-
sister?
thank you for the opportunity to speak. And jokingly, that my sister and I, say that, we're brother and sisters, but we're actually blood relation. And I too, I recognize the need for transparency and the concern for those individuals that are involved in the process of procurement. And I recognize as well, this just applies to procurement process. But that said, Madam Speaker, and I'm looking at how far we're going to be able to expand the definition of the immediate family. You know me, I love to think outside of the box and way beyond. And the concern that I got is basically, one, the precedents that we're going to be set in being able to now further to expand the definition of immediate family in this section, in this article, in this act. How is this going to affect the definition of immediate family in other places of the Guam Code annotated? What is that going to do for those definitions in those areas? And I have to agree with my good colleague from AFMI and my good colleague and my sister from Chalampago here that in the expansion of this, and I have to put myself in the place of an individual who really wants to be able to start a business, make a business, run a business beyond reproach and follow the ethics and be on the up and up. And then if to find to be discouraged that now I'm going to have to go get a family tree to figure out, who are all my relatives, and to get to them. The question that I've got, and maybe the question that I can yield to good author of this, is if in the case that there is a good faith effort to be able to obtain this information, but you got one of those siblings or you got one of those relatives where you're required to disclose their financial information, and they tell you, no way in hell am I going to give you that. Then what happens? Then we're going to penalize an individual for being able to conduct business in good faith because another adult whom really doesn't have to answer to this individual for any other thing refuses to provide the information. Now I can see where amongst our own immediate family with regards to our spouses and their children, but outside of that, what happens if what happens if you're fighting with your father-in-law and he doesn't want to provide you the information? And so sorry, Madam Speaker, it's a noble and it's probably ambitious to be able to say that we're going to be able to do this. And I just can imagine also some of the possible suits, legal implications, litigation that can occur as a result of this. Are we going to penalize you, Madam Speaker, if you had a business and you wanted to do business with the government of Guam? Are we going to penalize you because you can't get any information, or you totally forgot that, or you didn't know that you had an adopted brother? And so, again, my 2 points of concern here is the expansion of this, of the definition, how it's going to affect, how it could possibly affect other definitions of immediate family elsewhere within our code. But then more importantly is the ramifications if this cannot be satisfied. I just want people to know that the reason why I have the smile on my face, Madam Speaker, is because you're laughing up there. I can't keep a straight face on this. Okay, so for the sake of wanting to hear probably other discourse that will probably change my mind on this thing, I'll go ahead and sit back down. Thank you.
Thank you, Senator Blas. Is there anyone else who would like to speak in the motion? Senator Palacios, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in support of the amendments to this. Madam Speaker, grandparents, grandchildren, they're not far from, especially in Chamorro culture and our culture here in Guam, mother-in-law, father-in-law. We just about know what's going on in their family, maybe not to the same accuracy as we would know our own children. But I believe that the amendment here is to declare, to the best of your knowledge, whether your brother-in-law has an interest in that job which you have over which you have the authority to favor or to benefit. And if to the best of your knowledge you don't know, then no one can fault you that you don't know. And that's what it's all about. But then, on the other hand, if you knew, and then you failed to disclose that, and it can be proven that you knew, then they're going to get you. So this is more or less, I guess, just to make sure that one person cannot say, well, they didn't ask me. Well, they're asking you now. Now you have a chance to respond whether yes or no. So by dealing with this issue, with the requirement to declare whether your brother-in-law or your stepson or your stepdaughter-in-law has an interest, in a business of which you have an authority, like I said, to execute action that would benefit them, and you knew that and you don't declare that, to me that's a violation. And if you don't know and you declare that there's none, it can be found whether you really knew or not. And again, this is more or less just to put it in here, to make it more transparent. There's some degree of deterrence here to make sure, and if you don't know, then no one can fault you that you don't know. And I am not going to go about, if I'm going to declare, if I'm going to act on something over which I have an authority that will benefit people, I'm not going to go and check every stepson and stepdaughter-in-law and all those and grandchildren and do you have a business or not. To the best of my knowledge, if they don't, they don't. And I believe that I will prevail in any situation if I were to take that position. So again, this one does not create in no way any burden to anyone having to confirm this on this provision. Thank you, Madam Speaker.
Thank you, Senator Palacios. On the motion, are there any other speakers? Senator Pangilinan, you're recognized.
Just want to say, Madam Speaker. Madam Speaker, I think maybe part of the concern here is the two sets of laws that deal with the financial disclosure required. The bill being proposed, Bill number 12, is an amendment to the procurement law, according to the title of the bill. The financial disclosure under the ethics law for the determination of a financial interest and when can a person act in his official capacity that may affect a financial interest. So these two sets of laws work together, sort of. One is we need to disclose it. The other one is you have to know it to act upon it, and you have to recuse yourself from acting upon it when these relationships exist. In the financial disclosure law, the ethics law, financial interest means is defined that you have a financial interest, means an interest that is held by an individual, his or her spouse, natural or adopted or dependent children, parents, parents-in-law, siblings, or siblings-in-law, which is an ownership interest in a business, a creditor interest in an insolvent business, an employment or prospective employment for which negotiations have begun, an ownership interest in personal or real property, a loan or other debtor interest, or a directorship or officership in a business. So if your parents, adopted children, parents-in-law have these financial interests in these financial instruments, then you have a financial interest in there, and you have to be able to disclose that. It is pretty much the same definition in terms of the relationship in the procurement law, so that you, who has to file this interest already under the ethics code and under the financial disclosure code, you have to know these relationships. You now, who have a fiduciary responsibility and a fiduciary capacity to act on the expenditure of government funds and the awarding of government contracts in the procurement of goods and services for the government, if any of those kind of relationships exist between where your brothers, sisters, parents, mother-in-law, and so forth have an interest in, then you're precluded from acting and exercising your authority. So I don't think it's burdensome. We're not asking that your brother or your sister file a financial disclosure or you file a disclosure for them, but you have to know in order to comply with the ethics code and in order to comply with the procurement code, you have to know when those conditions exist and you are in a position to award a favor to them. And you should remove yourself from the ability to award a favor so that you cannot exercise your right to award a contract or give them, any kind of official action that advances their interests outside of the procurement law and the ethics law. You're precluded from acting and exercising your official authority. So this proposed legislation takes those relationships that you are already obligated to know when you file your financial disclosure statements and when you're going to govern your actions as a public official over to the procurement code as well. And so it may be burdensome, yes, and you do have an obligation to know the business of your family when you are spending government funds and they may be going to them. You have an obligation. Your brother, if your brother or your father-in-law has real estate all over the place, you shouldn't be in a position to say, this agency will now go rent from him. And if you tell me that you can't, that's too hard to find that out, or it's too burdensome to find out whether your father-in-law is owning the building that you're going to rent, then I'm sorry, but that is the responsibility you have, and that is the policy that this government's putting in place to assure the general public that this government and its officials will act in an unbiased and uninfluenced capacity. So yes, it may be burdensome, but yes, to be ethical takes effort. Every day when you get up, you have to remind yourself, I am in a position of government responsibility for my actions. I have the authority to act that influences this government, and I must ensure that I do it in an unbiased and ethical way. Every morning when you get up, you should be able to tell yourself that. And so when you find yourself in a position where that's going to come into question, you have an obligation to recuse yourself, to take yourself out of the decision-making process, to take yourself out of the discussion process on those matters that affect the financial interests of yourself, your family, your in-laws, your brothers, and your sisters. That's just the policy of this government. That is a good policy on this government. Maybe we don't do it enough. That's why we have a little bit of, it's too burdensome. But that's the proposal in this bill. I support it. I don't think it's something new. I think that if we are complying with the ethics law that is currently in place, this compliance with this in your official capacity will not be a problem, will not be burdensome, and will not be impossible to adhere to. Thank you very much, Madam Speaker.
Thank you, Senator Pangilinan. Senator Duenas, you're recognized on the motion.
Thank you, Madam Speaker. I would also like to ask the author to yield to a question.
Can you go ahead and ask your
yes.
question, and Senator would yield?
Yeah, my concern here is, so this would include the next fiscal year budget that we're about to vote on here as soon as we go through all that process. We're going to spend probably upwards of $1 billion, including federal funds, probably in this next fiscal year budget. And so,
Madam Speaker, if I may, and to address the question, and perhaps a little more generally, I think some of the members are reading too much into this. This bill simply expands upon current law. Current law provides in section 5628 of chapter 5 of title 5 Guam Code annotated under employee conflicts of interest, the current law says, conflict of interest, it shall be a breach of ethical standards for any employee of the government of Guam to participate directly or indirectly in a procurement when the employee knows that the employee or any member of the employee's immediate family, and this is current law, has a financial interest pertaining to the procurement. Now, what is being changed is simply the definition of immediate family, which is expanded in this bill. Now, what this means, ladies and gentlemen, is if you are in a position of authority as a government employee that has any control, influence, decision-making over a procurement action, and if a immediate family member is involved, you have to disclose that. Because if you don't, then you may have a conflict of interest if you knew you didn't have this relationship. The bill requires public officials, public employees involved in procurement, not to be involved in procurement decisions that involve their immediate family members. That's what this does. And it simply expands the definition of what immediate family members include. Because it's very obvious that the current definition doesn't work. We have seen countless violations of the conflict of interest provision and procurement in this government involving individuals who under the current definition may not be immediate family members, but in fact are family members. And this definition clears up what the definition of immediate family members should be in order to close these gaps that we have. Now, over the last 2-3 years, you saw a lot of this up close, exposed, thankfully, through the media, of these conflicts of interest in procurement, primarily. And there was very little anybody could do about it, because the definition of immediate family did not cover those persons. And that's what gave rise for this bill. We don't want there to be escape clauses and technical gaps and ways to get around our procurement laws. We want public officials, we want government employees to be accountable for their actions and their decisions.
Senator, well, we need to
And that's
just
what-
answer his question.
That's
and
what
then
I'm trying
I
to
will
do.
give an opportunity
I'm trying to
close.
say to the dear Senator, through you, Madam Speaker, that the intent of the bill is to expand the definition of immediate family, to close the loops on all of these procurement abuses that we have seen, particularly over the last few years, so it doesn't happen again.
I certainly understand the intent. I think there still is questions, Madam Speaker. Can we take a 5-minute recess to discuss amongst ourselves with this issue?
I'm going to take a brief recess. The legislature is back in session. Senator Dueñas, you still have the floor.
Madam Speaker, I would like to thank you and the good senator from Manila for giving me the opportunity to have the recess and get the clarification. Madam Speaker, I fully support the intent of this legislation, and it's been cleared up now. Where we got hung up is in the title, because of course, as appointed and elected officials, we have our Financial Disclosure Act that, requirements. And so the understanding is this is for the procurement in the government of Guam and our understanding in terms of what we do in our offices. So what I'd like to propose is to amend the title to remove the "to" after relative and Financial Disclosure Act, as the language already in the procurement law covers the extent of what's being proffered here in this proposed law bill. And so if we could make that amendment, I think this will clear up some of the confusion and make it more understood.
Okay, so the amendment then is to delete relative and financial disclosure. So read, define, and expand its definition to the public official.
What we would do
To
is
public
after the word relative, we'll take out the word "to,"
Oh,
and we'll
okay.
continue with the public official, and then we'll take out Financial Disclosure Act. So it'll read, basically, to further define and expand its definition relative, we're going to need to leave the "to," excuse me, relative to the public official.
Or
And then-
relative to public officials.
Right, and then take out Financial Disclosure Act.
Okay, so it should be to further define and expand its definition relative to public officials.
Correct, Madam Speaker.
On the amendment, no objections, so ordered.
Thank you.
Clerks, were you able to get that? Is there anybody else who would like to speak on the motion? Senator Guthertz then to close.
Thank you, Madam Speaker. I have one minor amendment. It was brought to my attention that the word adopted is already in the law, and it's already covered. So I would like, and I passed out the amendment, simply to amend line 6 and 7 to read as follows. Sisters-in-law, daughters-in-law, sons-in-law, and step-members shall also be regarded as immediate family.
Sorry, Senator Guthertz, one moment.
The word adopted is already included in the law, so we don't need to replicate that in the definition of immediate family that we're presenting here. It's already in the law. So I'm revising, my proposal is to revise line 6 and 7 to read as follows. Sisters-in-law, daughters-in-law, sons-in-law, and step-members shall also be regarded as immediate family.
On
That's the
amendment,
motion.
Without any objections, so ordered.
Thank you, Madam Speaker. I'd like to thank my colleagues for being very patient on this, and I encourage them to support this bill. Thank you.
You're welcome, Senator Guthertz. I think there might be a concern, maybe possibly to clarifying the title. Legal counsel is working with the mover, the mover of that amendment. So can you make a motion then, Senator Dueñas? Notwithstanding the actions of, the body, if you can please go back to your, for an amendment then.
Yeah, if I may, Madam Speaker.
So on that motion, then you don't have any objections, that he goes back to redefine the title. Okay, so ordered. Thank you. So Senator Dueñas?
Yeah, it appears as though we have to be a little bit more clear, as that doesn't clear up everything in the title. So what we will do now is define and expand the definition of immediate family member in public procurement.
Okay.
Okay.
Clerks, do you have that? Can you please also make sure that we get that in writing to the clerks?
Yes, it's legal
So it'll
counsel
be
is.
to further define and expand the definition
of
immediate
immediate
family
family in public procurement.
and public procurement. Without any objections then, so ordered. Thank you very much. So on the motion then to send, Senator Tyron?
I
apologize for going backwards, but I just wanted to know if there could be a bit of a clarification here where we're talking about on line 6 and 7, where we say adopted and step members. Can we clarify, are we talking about adopted children and stepchildren?
Madam Speaker, as you recall, we
Adopted.
just amended that section, and we took out adopted,
Okay,
because that's already
Yes.
an existing law.
okay.
That's an existing law.
So the question then of step members, whether members
that
could be
stepchildren?
children?
Can we say
Well-
stepchildren?
Yeah, it could include children, or it could include other
Stepmother,
members that are
stepfather, okay.
step, yeah.
Okay.
I don't know who they are, but it could.
All right, thank you.
So, and any step member could be children, brothers, sisters. Yeah. Senator Tyron, I know that step member is a very general description. Do you want to amend that by being very specific to stepchildren or step?
Well, if the body doesn't think it's necessary, if step members, if that general clarification. I've never heard of a step uncle or a step aunt, but
It's
I've heard
mostly
of
stepchildren.
stepchildren and step parents, mother and father. So if it's
How
not
about-
necessary,
Okay, maybe the safest would be step siblings.
step siblings.
Then that would be all inclusive, or, see, that's the thing.
Perhaps the legal counsel could.
Let me take a brief recess, okay?
I think I'd just leave it alone, then it becomes more complicated. You have stepmom.
Make an amendment to clarify that it's step siblings, step children, and step parents.
Okay, on the amendment, without any objections, and so ordered. Thank you very much, Senator. So on the motion then to send Bill 12-31 COR as amended on the floor to the third reading file without any objections, so ordered. We are now on Bill number 18-31 COR, and I recognize the author, Senator Ada.
Madam Speaker, I move that Bill 18-31 COR be moved to the voting file, and I would like to discuss it.
Yes, you may continue.
Madam Speaker, first of all, I want to just kind of lay some background and the question of, well, so why Bill 18-31? In the 30th Legislature, Public Law 30-199 was enacted into law, which adopted Guam's new building and fire codes. At that time, we replaced the building code that we had been using for the last 20 years, a code that had not been updated for that long of a period. Since then, of course, under Bill 30-199, we adopted a new building and fire code. Public Law 30-199 also created mandated that a task force be formed consisting of GovGuam and community stakeholders to spearhead the creation of a Guam Building Code Council. Now, in formulating Bill 18-31, the task force was formed, and the Committee on Public Works actually chaired that task force. And it met regularly since September 29, 2010. And it included representation from the Department of Public Works, the Guam Fire Department, from the Guam Water and Guam Power Authority, representatives from the Guam Board of Registration for Professional Engineers, Architects and Land Surveyors, otherwise known as Appeals Board, representatives from the Guam Chamber of Commerce, the Chinese Chamber of Commerce, the Guam Contractors License Board, the Guam Contractors Association, the Guam Society of Professional Land Surveyors, the Guam Society of Professional Engineers, the Guam and Micronesia chapter of the American Institute of Architects, and the Guam Association of Realtors. So as you can see, the task force was very well represented, the stakeholders in the community who have to deal with the building codes and the fire codes on Guam. The findings and the recommendations of the task force was then provided to the Legislative Committee on Public Works and then translated it into Bill 18-31. Now, the purpose for creating the Guam Building Code Council is in order to have an organization, a council, that will review and initiate the process for the adoption of updates to Guam's building and fire codes. Now, in the 30th Legislature, when we adopted the International Building Code, it was only, the entire code was not adopted, simply because there were some codes, provisions of the code, which may not have been applicable to Guam. So it was really adopted partially, with the understanding that once a council was created, it would then go back and take a look at provisions that should be added to the code. For example, in the International Building Code, it has a provision in there for an energy conservation code. Well, it was deemed by the task force that many of the provisions in that part of the code really were not applicable to Guam, but that instead effort had been put previously in developing a tropical energy conservation code, a code which was really more suitable for this part of the world. And so the council will be looking at that and once again confirming that that is the code that we should be adopting for our energy conservation measures. The other function that the Guam Building Code Council will play will be really an appeals board. We have situations where a developer brings in his plans to get it permitted for construction, but there seems to be a dispute in the interpretation of codes. The fire department may say, no, the provisions of your plans do not comply and therefore is denied a building permit. And at this time, right now, there's really no recourse for this dispute to be resolved. So the second role that the Building Code Council will have is to then be an appeals board where this dispute can be brought to and then reviewed by the professionals that are sitting on the council and determine what is the proper interpretation of the code. The Building Code Council will be comprised of 7 members, 7 appointed members, and 2 ex officio members, for a total of 9 members sitting on that board. The 9 members that will comprise this council will consist of an architect, a licensed general building contractor, a licensed real estate professional, 2 members of the general public, of which one of them must have some familiarity with requirements, at least with the barrier of barrier-free architecture, and is aware of and sensitive to the requirements necessary to ensure public buildings are accessible to and usable by persons with disabilities. It will also consist of a professional engineer specializing in structural engineering and a professional engineer licensed in Guam specializing in either mechanical, electrical, or fire protection engineering. The director of the Department of Public Works and the director of the Guam Fire Department, which will be the ex officio members by virtue of the positions that will be sitting on this council. The appointments of these 9, well, actually the 7 members, because your 2 ex officio members are actually already been appointed by the governor and have been nominated, have been confirmed by the legislature. So the appointment of the other 7 members, the engineers, the members of the general public, etc., will be appointed by the governor and confirmed by the legislature for a term of 5 years, with the exception, of course, of the DPW and GFD directors. Now, once the council is formed by virtue of enactment of Bill number 18-31, the council will then will go through a process of creating. The council will then have to convene, and it will then begin formulating its rules and regulations. And the adoption of the rules and regulations will be in accordance with the provisions of the administrative adjudication law. The funding for the operation of this council will come from the revenues that are generated from the contractors' licensing and fines and penalties, the same revenue source which currently funds the contractors' licensing board. And there is sufficient funds that is generated to be able to support the budgetary requirements for the Guam Building Code Council, which will basically be your standard $50 a month for your board members, and the hiring of possibly an administrative assistant and some other office expenses, but certainly nothing significant. But nonetheless, at the public hearing for the bill, there was, of course, unanimous support of the people who did come in, testifying that it is important that we have this council to meet those 2 requirements that's with respect to the building and the fire codes, and that is to provide updates and to perform the function of an appeals board in the event of a dispute regarding the interpretation and the application of Guam's building and fire codes. So, Madam Speaker, I would ask my colleagues to please support 18-31, and it would bring closure then to the requirements of establishing our international or our new building codes, in addition to then having a body that will oversee the updating and the proper interpretation of the codes. Thank you.
On the motion, I recognize Senator Palacios.
Thank you, Madam Speaker. Madam Speaker, I rise in support of Bill 18. Madam Speaker, I attended the meeting during which time it was discussed the new codes, the so-called new codes, actually the updated codes. And at that time, I guess it was recognized that there's going to need a transition period for a complete adjustment and a complete settlement of, I guess, from the old code to the new code and the different processes. And at that point, it was, I guess, noted that there need to be some kind of body, and so hence the council. And actually, the purpose of the Bill 18 in establishing the council is to review and initiate the process for adoption of future updates to such codes, as it was recognized back then that there would be a need from time to time of an adjustments, and also that the council will also serve as an appeal board for disputes related to orders, decisions, or determination made by the government of Guam entities relative to the application and interpretation of the other building codes. So it was recognized back then that there would be opposing processes during the transition period from the so-called old codes to the so-called new codes. And I say so-called because actually the one we call old codes are merely carryovers. Probably upwards of 85, maybe 90% are actually carryovers from the old codes. And why do we call them a new code? Is because now it is an international, it is compatible in nomenclature and in definition with the international building codes. And I guess we need to adopt this in light of the current trainings of these engineers. They study in the mainland, and these are the different codes and nomenclatures that now they use. And unfortunately, our old codes do not reflect the contemporary practice and policies, I guess, and procedures of what this country adopted as a new codes for the building codes. So the purpose of the council is actually in anticipation of resolving some of these issues as we go along. There would be an adjustment period. I understand that, I guess, after 3 or 4 years, things would be settled, and then from there on, it will be merely just amendments, maintenance effort to continue to just update the codes and be in compliance internationally with our counterparts. And with that, of course, we need this so that the new codes can be implemented in a more efficient way and be resolved if there's any conflict. I rise in support of Bill 18, Madam Speaker. Thank you.
Thank you, Senator Palacios. On the motion, Senator Respicio.
Thank you very much, Madam Speaker. Madam Speaker, I too rise in full support of Bill number 18-31, and I also rise to share an observation and how our oversight chairman has been able to take a very complex issue and simplify it to the extent where everyone can understand what he's attempting to do here. But in the process of taking this very complex issue, Madam Speaker, I want to share an observation because I did attend the public hearing to which he chaired. And I want to share an observation that just goes to show that when you involve different constituencies from the island and bring in all the stakeholders, holders, as he has done, it kind of diffused the resistance toward wanting to implement this international building code. As we know, this is something that the good senator inherited when the previous legislature moved to adopt the international building code. Public Works was not ready. They were not ready to move forward in this direction. And as soon as he resumed oversight over this particular subject area, the first thing he did was to call all these individuals in. And as we know, the biggest bone of contention with the implementation of this code was the sprinkler system. And whether or not you can take an international building code for one jurisdiction and fit it into a jurisdiction such as Guam, and to say that one size fits all. And certainly that doesn't work, won't work here for our island and for our needs, and hence the reason for something like this. So I just rise to commend Senator Tamata for his ability to bring different people together and for his remarkable ability to, again, take a very complex matter and simplify to the point where all parties involved are appeased. And they're appeased, Madam Speaker, because they're involved. And when you involve people, you create buy-in, and this is the way you can move these kinds of issues forward. So I rise in support of the bill, and I thank you for giving me the opportunity.
Thank you, Senator Respicio. On the motion, Senator Dueñas, you're recognized.
Thank you, Madam Speaker. I also rise in full support of Bill 18-31, and I'd like to commend the author as well and thank him for including me. This was actually my first piece of legislation to be a part of as a co-sponsor on this legislation, and so I appreciated the opportunity and the outreach. I was concerned as well, and I followed some of the issues while Senator Atta was trying to solve the issues related to this complex code. And I remember a number of phone calls into the radio station and publicly stated by members of the community who were apparently were adversely affected by one fell swoop of a code being implemented. And I commend the author for really moving forward and clarifying. And what I really appreciate about this piece of legislation especially is the appeals process. And that's correct even by the retiring speaker, that there is not a one-size-fits-all, especially when you've got very voluminous regulations that exist in other jurisdictions. And so this is, I liken it unto the appeals board with the opportunity to go forward and handle disputes in that matter. And to me, that is the greatest mechanism contained within this bill, just to resolve disputes and to clarify the codes. So I commend the author. I appreciate his outreach and look forward to voting on this legislation when we get to the voting file. Thank you.
Thank you, Senator Dueñas. On the motion, are there any other speakers? Senator Pangilinan, you're recognized.
Thank you, and Sadismasi, Madam Speaker. Madam Speaker, I rise in support of this. Even though I didn't support the original bill that put in the Guam Building Code, I think we're beyond that now. I think that effort and work has gone in to make the implementation of the International Building Code work for Guam, and certainly that is moving forward, and therefore I support this continued effort to ensure that it works fine, even though the initial change out I did not agree with. I think I'm way beyond that now. I think that the author has continued to pay attention to the matter, work with the matter to make sure that we have the users of the code, those that are affected by the code, the stakeholders in the process all have come together and are now moving them forward and trying to make it work. And therefore, despite my initial objection, I certainly want to lend my effort to that progress that is being made. And so I support this bill and want to articulate that. I do have some concerns in the bill only because of the recent controversy that we've had with the governor and the appointment of the Guam Memorial Hospital Board of Trustees and the law that was passed that's in place. And I see some similarities between what the Attorney General and the governor has and his legal counsel has said are inorganic with the process of impaneling the Guam Memorial Hospital Board of Trustees with the conditions here. And they may not be on case and on point, but there are similarities which we may want to just look at, think about, that we may need to maybe find alternatives for. The idea that the governor, that somebody else can make the appointment, I think is something that may be subject for debate. It is very clear that the supervision of the executive branch is under the authority of the governor. The boards and commissions such are, unless specifically fixed by the legislative body through a process that meets a test of certain cases, Myers being one of them that was cited. So there may be some question on whether or not we can have somebody else do the appointment, which we have here if the governor fails to appoint a successor. They may be that the council may appoint that member. We have the same question, Madam Speaker, in some other bills that we've passed in the legislature, where if the governor fails to make an appointment, the speaker can appoint. And we've had that debate on the separation of powers issue and those matters. So I think it's fine because we do have a severability clause and all the other elements can proceed with the implementation. But just as maybe just as thinking out loud, you might want to say, I think that there may be a point in time, and it'll only be a point if the governor doesn't want to, wishes to challenge it, I guess, because if the body approves this in this fashion, then of course we say that this is the policy. If the governor signs the bill into law and implements it and nobody challenges it, then we're fine, we move forward. But if the governor decides that no, he wants to continue to protect his Organic Act authority, assert his Organic Act authority, he may find some reason to say, well, I don't like this provision or I don't like that provision and I'm going to veto the bill. Or else I'm not going to implement this portion, and we may find ourselves once again taking a look at a controversy where we may have been able to avoid it. I don't know how to fix it at this time. I'm just saying that I think that's something that the body needs to be aware of in the way that this bill is being presented. And again, this is nothing saying nothing about the work of the author, because this is how we've done other things. And only with this recent controversy of all of these issues resurrected themselves. And we just have to be more cautious and more cognizant of those issues as we move forward on legislation through this body. Thank you very much, Madam Speaker. And in its current form and in its current context and content, I support the bill. Thank you very much.
Thank you, Senator. Any other members who would like to speak on the motion? There being none, Senator Tom Addett, would you like to close?
Thank you, Madam Speaker, and I appreciate certainly the support that has been expressed so far. To the issue about the organicity, I guess, of how the appointments are going, that Bill 18-31 proposes, I guess the fact that the Attorney General's office has given an opinion that nominating counsel, for example, for the hospital is inorganic, and that therefore the similarity of that particular arrangement with what's proposed in Bill 1831, wherein, for example, the Guam Society of Professional Engineers will provide a list of names, not one name, but a list of names for the governor to be able to select from and to appoint to the board. So it is the scheme in Bill 18-31 is similar to what you have right now with appeals board, where they actually provide recommendations for names. I understand that the recommendations for a judge also comes from the Guam Bar Association. So certainly, if the organicity of the hospital, that nominating council, is being questioned, then it does have a far-reaching impact, because we have many similar setups right now, which, although not quite germane to 1831, maybe actually is the premise for why we should put forth the question of for declaratory judgment on that particular issue. But nonetheless, I'm satisfied. I mean, I'm confident that if Bill 18-31 goes through, that's not going to be a significant issue, hopefully. But I would just urge my colleagues to support 18-31 so we can put the issue of building codes, bring closure to that, and allow us to continue moving forward. Thank you.
On the motion then to send Bill number 18-31 to the third reading file without any objections, so ordered. Senator Barnes is not here. I'm going to move on to substitute Bill number 32-31, COR, and I recognize Senator Yamashita.
Thank you, Madam Speaker. I ask that Bill 32 be sent to third reading file, and then I be allowed to speak on it. Oh,
Go ahead. Please continue, and you would like to discuss it?
yes, please.
Please proceed.
Madam Speaker, Bill 32 is an act to amend subsection 3102.1 of Chapter 3 of Title 17 of the Guam Code annotated relative to the duties of the Guam Education Board. Madam Speaker, as a result of our public hearings, which were held on March 17th, the substitute bill is actually a combination of Bills 32 and Bills 93. Both had the identical intent to clarify the duties and responsibilities of the Guam Education Policy Board. Public Law 3183 had relooked at the structure of the policy board, and it resulted in a hybrid structure or model for our public school system. As that went forward, there was questions, great conversation about what exactly they were authorized and responsible for doing. As a result of hearing those conversations, those particular two bills were introduced. And so we know that across the nation, overwhelming majority of our education boards are policy boards. We do know that when they become operational, there's great questions about what exactly it is they are to do. We do know that there's great concerns about micromanaging, and this particular bill, 32, specifically states that the Education Policy Board will not engage in any micromanaging. This bill also makes it very, very clear that the superintendent of the public school system is responsible for what happens with our students in our schools, and is to be held and has the accompanying authority to ensure that learning opportunities are provided for all students. And so then therefore, when the issue of why didn't something happen is raised, that question falls right in the front of the sitting superintendent. This really helps with accountability measures. And while, if you read the committee report, you will see, and Madam Speaker, you were there, so you will remember, that nobody actually came forward and spoke and gave any public testimony on Bills 32 and or 93. But we do know that as we've spoken with a variety of school leaders, with superintendents past and present, with board members past and present, truthfully, there was a mixture of testimony. And, but as the committee report summarizes, we do ask that consideration be given to Bill 32, which again clarifies with letters A through Q on the second and third pages of what exactly our Guam Education Board shall be accountable for. And so with that, Madam Speaker, I ask for the consideration and the support of our colleagues.
On the motion, are there any speakers? Senator Pangilinan?
Thank you very much, Madam Speaker. You know, Madam Speaker, once again, we're back in this body trying to clarify the intent of the legislative policy with regards to the elected school board and the powers vested in its members. And the debate has always been policy operational. When does one cross the line and that interferes with the management of the school system itself? I've always been a proponent that you really can't, you know, slice it like that so clearly. That it is unclear, it is muddled, I think, of what is policy and what is operation, and when does one cross the line. And if, for example, as I give sometimes, when a school board member is at a school and he sees that there's no teacher in the classroom, if they go to the principal and say, hey, can you see and can you get a teacher there, is that policy or is that operational? Clearly, I think, I don't know what it is. Clearly, I don't know whether it's operational and whether that board will now violate this policy because he's going to a principal directly and saying, there's no teacher in that classroom, can you get one? So what do we do with a board member who decides that they're going to do that every time they see it because it affects the school children? Are we going to discipline that board member? Are we going to say, you are interfering in operations, you have no business? No, I think, for me personally, he has every business. Just as any parent has every business to go, and when he sees that there's a school, there's kids in the classroom, there's nobody there, you bring it to the attention of the thing and of the principal, and you say, do something about it. So, you know, so when we try to just box out these kind of things, and maybe it's a bad example, I don't know. But that's why when we kind of say, you can't interfere in this, you can only do this, and make it so dogmatic that we then end up arguing what's that action constitutes, and we forget about ensuring that the system works well, and the goal is to have a teacher in that classroom, no matter how you do it. You know, maybe you can't order the principal, maybe, but you can ask them. So I read the bill, and everything makes sense. There's nothing in here that I don't really agree with, or I mean, that I really disagree with. I mean, I think that it is necessary to say that these are the things that the board will concentrate on. But what do we do when these things aren't happening and, you know, you see it, can you act on it? Or must you now pick up your cell phone or drive downtown and tell the superintendent, because you're a board member, superintendent, there's no teacher in that. Can you even do that? Can you do that on a day-to-day basis, or do you have to wait for the evaluation of the board, of the superintendent? Can you hold the superintendent accountable for, I guess you can, for the day-to-day operations? But I don't know that it actually, I guess it does, because it addresses the proper administration of all mandated responsibilities. But how do you do that? How do you do that as a board member? And when do you cross the line? Is telling that superintendent right then and there, or is it only at a board meeting, or is it only during the evaluation, and you just ding them? So, again, I understand and I see the rationale and the intent of Bill 32 in outlining those responsibilities, and I don't have any disagreements with that. But to say that, you know, if we just take the board members out of operations, then we're going to fix the school system. And that's been the problem all along. Maybe the problem is they haven't been in operations. I remember a school board that, you know, I attended many school board meetings with that school board, and it was clear that they were interested in the operations of the school. And the good author knows, because I think she was in the administration for a time when that school board was in place, and things ran well. Somehow, even though I look at it and, hey, they were clearly crossing the line between policy and operations, but the schools ran well, the board and the superintendent communicated well, policies got put in place and executed, and it was only when the external factor came in from the gubernatorial side that interfered with that we have the chaos. So the idea that we're going to fix it by, you know, just saying the school board can't do operation and we're going to work that way, I think is not, I think, the be it and end all for the solution to our school system. And I think it may unfairly, I think, place maybe I blame or the cross of the inefficiencies of the school system on board members who are there for one simple reason: they want to dedicate and serve the public school system and make things better for the students. And then to, you know, for us in this body, and not just this legislation, but in the past, even more severely in the past, I think try to vilify the school board members because of how they are carrying out their duties and responsibilities, and then placing the blame on the structure and the system itself, I think is just not fair. But once again, I do want to reiterate that I think that this is a good thing. It places clearly, at least, that the board will focus on these issues and these areas, and they will be judged, I guess, by the voters who put them into place on how well these are put in place. Not how well the kids are getting educated, because that now will be up to the superintendent. The test scores and all that really should be the superintendent, and so forth. But I'll tell you what, it's going to be the school board that gets blamed if the test scores are down. Nobody's going to blame the superintendent. Nobody's going to blame the teachers. We're going to blame the school board, and yet they can't do anything about it because their policy, and that's operations. So it really is a dilemma, I think, and you know, and we're not the only ones struggling with the most ultimate system for accountability and progress in our public educational system. Thank you very much, Madam Speaker.
Thank you very much, Senator Pangilinan. On the motion, I recognize Senator Dueñas.
Thank you, Madam Speaker, for the opportunity to rise in full support of Bill 32-31. I'd like to commend the author for her diligence, and I would also like to say that, Madam Speaker, we just recently also passed legislation that I know that you were in full support of to create a hybrid to this board in order to bring more stakeholders to the table and to diversify the board and those who understand the difference between policy and governing when it comes to education. And I tend to differ a little bit with the retiring speaker. While I'm glad he's in agreement of the intent of this legislation, I have to say his example reminded me of the Good Samaritan law somewhat. That, I think anyone who sees deficiencies in the school system, you don't have to be a board member to see if that there's a teacher not in a classroom or some sort of deficiency within the school system that you observe. Anyone who has the God-given interest in our children and their future should jump in and deal with those issues, regardless of whether you're a board member or not. The one reason why I even was willing to be a co-sponsor on this bill, because I remember not too long ago when we had to have a discussion with federal officials on the board's interference with regard to programs administered under federal dollars. We had to separate out what programs were going to be administered and what the board had authority over. And that came at a time when those monies weren't even being released. And we all know the financial condition of our government. We can ill afford to ever go through a situation whereby funds are restricted because we may make policy calls that cross over into the administration of federal dollars for programs that are paid for by the federal government. So I see this as an important piece of legislation. While I have supported on numerous occasions a lot of what the good, hardworking, duly elected members of the boards ever since the enactment of the legislation to have an elected body once again, I still believe, just as we elected officials and everybody else who serve at the pleasure of the people, need to be reminded of our boundaries and how far we can go when we carry out our duties and what is the extent of what we're put in place to ensure accountability for. So I would like to once again commend the author, and I believe we have an example or perhaps other examples of where sometimes authority needs to be questioned and reined in so that the true best interest of service. And once again, I reiterate, I was at a function last weekend where I was approached, and I believe we have legislation that's been introduced, that while we were well-intended to put a member on the board, it made a 10-member board and turned out now that could hold up the budget. And so I believe we're going to make that member a non-voting member, so we go back to an odd number, and that perhaps the less experience of this particular youth member, will be considered as what policy goes forward, but not to deal with a $400 million budget or $329 million budget inclusive of federal funds. So I like the fact that we're being cautious here. I like the fact that we're putting parameters in place so that we don't sacrifice the entire system for the good intent. Once again, I commend the author and thank you for the opportunity to speak on this bill.
On the motion, I recognize Senator Barnes. Munya Barnes. Tina Rose Munya Barnes.
I like that,
Senator
Madam Speaker.
Tina Rose
Cesar
Munya
Suarez.
Barnes.
Thank you for giving me the
Legislative
opportunity
Secretary.
to speak and rise in support of this bill number 32-31. And Madam Speaker, I'd be remiss if I didn't say that I know you had a very, very similar bill, and that was bill number 93-31. And I guess with the bipartisan support and working closely with our new colleagues, our freshman colleagues, I'm glad that both bills got integrated and put into one. As earlier noted, I do rise in support of the intent of this bill. I do have a question, however, for the author or you, if you'd like to answer her, and it's on page number 3, and it's sub-item Q, and it says, each newly elected or appointed board member shall complete during the first year of the member's first term a training program to be prepared and offered by the University of Guam and the department regarding the skills and knowledge necessary to serve as a local school board member. And then it goes on to say the training program shall include. My question to the author is there a program already or curriculum set into the university's program? And if so, will there be a fee for this? And if so, do we need to add any funding to this part? I just wanted to make sure. Okay. Oh, okay.
Thank you, Madam Speaker. And Senator Munoz-Barnes is absolutely correct in that it was a show of bipartisan collaboration where Madam Speaker allowed both of our bills to be merged, and this is the birth of that. And so I thank you very much for that. This is a part of the original 93, and I believe that a training program had been offered, and it can be offered, and I think it was usually through the PPEC, and I'm trying to remember what that stands for, Professional Program Education PPEC. I know Rita Edwards used to run it, and now I think she's taking care of herself, so I think Mr. Larry Gamboa is running it. But I think out of that particular unit, there are training components. Is there funding for it? It's supposed to be included in the budget for the board.
Yeah. So, Madam Speaker, based on that answer from the good senator of Tamuning, I just want to make sure that if we implement this, that financing component is part of that, because as you know, that same training or a similar training was offered to our freshman senators and also to our members who wanted to go for retraining on I want to say the ethics training program. And in the beginning, it was offered as a free service, and then at one point, you almost charged us for it. And I just want to be assured that if this happens for these folks, that if the program's in place, if there's going to be a fee, let's set it in now. Let's include it in this bill. So I don't want to make any amendments at this point. I just want to be able to just bring it up to both your attention so that if we do need to put a financial component in this measure, that we do so before we bring this down to third reading. But again, I want to thank you for giving me the opportunity, Madam Speaker, to speak in full support of this bill. And I hope my colleagues support the same. And I hope that by the end of this, before the bill goes down to third reading, that we at least address that. So thank you very much.
Thank you very much, Senator Tina Rose Munoz-Barnes, and I need you up here.
Madam Speaker Wampat, you're recognized on the main motion.
Thank you very much, Madam Speaker. Madam Speaker, excuse me. I rise in support of Bill number 32-31, and it was substituted by the Committee on Education and Public Libraries, and it was an effort between the author and my office as well to look at both bills because they're very similar. It's just that one bill was more prescriptive, delineated the duties versus the other, which just actually qualifies the board in terms, I guess, to kind of settle the argument of whether it is a policy, it is a governing board, and 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 that has always been a very big issue with members of the board. In my research and even in participating in a training similar to the topic, of course, that you brought up on page 3Q, where there was a governing board training of which included the Guam Community College, UOG, the community college in Saipan, the community college in Palau, and even the public school system in Saipan. And there was an extension, an offer to the board members here in Guam as well to participate. And I even offered to try to assist even for the members in funding the trip over to Saipan for this training, which was really going to be free. All they had to do was to pay for airfare. But unfortunately, the members didn't attend from Guam, and I say it is really unfortunate. And I decided to attend that meeting myself because there was that big argument of policy versus governing. And really, when you look at it, any board that sits for a department or an agency really is a governing board, and that governing board sets the policies for that department or agency. But what really matters the most that I got out of that training was actually the members themselves and how they see themselves as members of the board. Whether do they really want to go in and be hands-on about what their responsibilities are, or their duties, or what their roles are. And there are board members that would not even want to do that. They want to be able to go in there, have the department or the head of the department report to them, keep them abreast of what's going on. And usually it will be that person who will make recommendations to the board then to take some action. Now, I sit on a couple of boards myself, and I surely do not take the position at all either is to go in and try to micromanage what goes on there, but rather hold the director, hold the CEO, hold the president of that board then to come to us and make recommendations. And when the director prepares the agenda for the evening or for the day or for whatever times that we're meeting, is that you go through the whole process, the standard, agenda, and then you come to a section, of course, where it says action must be taken, where the members will vote on a policy or a procedure or something of that nature, but never, ever to go in and then actually try to micromanage. Now, I've been on the other end as well, where I was a school principal, and I've had board members come to my school and, inspect my school. And not once have I ever had a board member come in and tell me either how I should run my school, or that I should be at a certain place, or I should be, downtown, or that maybe my assistant principal wasn't there or whatever. But then again, it's the character of the individual. If someone did say to me, at that time, you say, Madam Principal, you don't have a teacher in that classroom. If anything else, I'll be very appreciative of that statement, because then I want to make sure that I do have a teacher in that classroom. I'm surely not going to say, you can't tell me that. You're micromanaging. I only report to the superintendent. So a lot of it really is the character of individuals who are serving. The second thing that's also very important, yes, is the training of these individuals. And that was the reason, for this particular amendment here, is to make sure that actually happens. Because they need to understand, everyone needs to understand that whenever you're sitting in any board, any council, any commission, you really must know what your roles and responsibilities are. Now, the one thing that was very clear in the public hearing for both bills, and as a matter of fact, even before the bills, it was just the members themselves. We wanted to know, where are these members coming from? How do they see themselves? Do you consider yourself a policy board member, or do you see yourself as a governing board member? And every single one of those individuals that came before us testified that they're there as basically policy members. They're there because they want to make sure that it is the superintendent, that she is being paid this high salary. It is her duty and her responsibility to make sure that the schools run, that the department is running efficiently. And if there's anything, of course, that she may need, she is to come to them. Now, if they feel, however, she's not carrying out her duties as specified by law, then of course, since they hire the superintendent, then they definitely would evaluate the superintendent, and ultimately they can either fire the superintendent. That's their very specific, hardcore, duties and responsibilities, aside from all these other duties and responsibilities that are listed here in Bill 32. So, Madam Speaker, what I really am trying to impress upon our colleagues here, because I know there are those of us who feel, yes, sometimes it would be good to get the board members involved to the degree that they would know what's going on, and wanting to make sure that the superintendent actually makes sure that that's happening. Then, I don't really see a real harm in that at all. I mean, they're past. I know directors, they're directors then, now we call them superintendent. And yes, under even the leadership of Mrs. Nelson, who was a director before, Mrs. Nelson, who was the chairperson of the board, and our member, our colleague here, Senator Guthridge, was part of that, both the elected and the appointed. And both times, regardless whether they're appointed or elected, they truly conducted themselves in the manner in which that they're there as really policymakers. I didn't see a single one of them at least come into my school. I don't know why, maybe not my school. I know I've heard some principals say that other board members did come in to see them. I know that individuals at the business office also had indicated to me that other board members have come down to them and said, I want this report, I want that report, only to be told that, she gets her instruction from the superintendent or the director then. So it really, again, like I said, it just boils down to how an individual thinks of their own position, how they feel about, how they should operate. So, it's an individual personality thing. But the most important thing I honestly believe has happened, because and several of us were in the Department of Education, and we've seen this, and we've really seen how we've grown and developed, how we've changed. And I honestly believe that we have a board now that has really matured from the very beginning when we first started to have this problem, because it was never really an issue until all these challenges were brought to either the courts or the board members themselves, or to the Department of Education employees. That's when this started to heighten, and everybody just wanted to know the difference between the two. But they really are, synonymous. So, and I hope that would have clarified, some of the concerns that maybe any one of you should have. The one I was thinking, Madam Speaker, as I was looking through here, is that I know that, yes, we can have a long list of duties and responsibilities that we want to itemize or delineate here. But I was just wondering, and this is food for thought for our members to consider as well, is that, how it is when we have our position descriptions, usually you have that last sentence there, and other duties as, prescribed by law. And that, will happen, I'm sure, throughout, the days in which, of course, the legislature is operating. And sometimes new things, new programs, maybe. I can't identify what those are, but the possibility of saying that then maybe, the catch-all phrase that, and any other duties, again, as prescribed by law, so that the members don't say that, well, it's just, A to R, and that's it. Don't add an S or a T or whatever it is, because it's not there. But it may be prescribed, later on. So I want to give that some thought, because I just thought about it. But what I really like to do here, and I have not passed this amendment out, but if I may just real quickly, just at least plant the idea in your minds, and then I'll have copies made, and then you can read it. But I really wanted to add a new section 2, and then of course 3 will be it'll be enumerated later on to, the severability clause. And it's that it would actually include with one of the members who is one of the board members, and that board member really is the student member. And to say that the board shall have the following non-voting members serving a term of 1 year, and that is one, of course, that the student member who is there shall be elected by an island-wide school board. That's there already. But the student member shall be a junior or senior at a public high school and maintain a grade point average of 2.5 or above. And then the second is one member appointed by the exclusive bargaining unit, which represents teachers and other employees of the department. So that is the amendment, and if I may, I can have copies then, Sergeant at Arms, made for all of our colleagues for you to think about. The reason for the amendment that I want to proffer, Madam Speaker, is because if you recall, I know last year when the bill was being discussed on the floor, and one of our colleagues who's not with us, this time around, but had made an amendment to increase the number of members to the board, and in doing so, and I'll admit, I now accept, of course, fault for that. It's not going back to kind of count and make sure that, that we really have, an odd number members on the board and who's voting and not voting, and it was an oversight. This was one, and unfortunately, this one slipped through the cracks, and it makes it very difficult for the current board to even continue in its deliberation, knowing that by chance, there would be a 5-5 vote and nothing would ever get done. And it's kind of unfortunate because, even in the few times that there may be some informal type discussions, even at the time before we had confirmed the members, to kind of just see where everyone's coming, and already we were noticing that they were starting to polarize themselves, and that's the way things are actually happening. The other is, and I'll never forget, of course, Mrs. Nelson, when she came to me at the time, when this was being discussed, even as early on as the 24th Guam Legislature, 23rd and 24th more in particular, nothing really happened until the 26th, when Public Law 26-26 was passed at that time. And Mrs. Nelson's plea to me was that, when she herself was the chairperson of the board, and even when she was the director, one of the things that she felt was so important for her to do was to protect always that student, because automatically sometimes when there are certain issues to be voted on, and seriously, you can see the adults as going there wanting to intimidate sometimes the child. And Mrs. Nelson would always try to take that child away, alienate the child until such time that then they're ready to vote, in the hopes that nobody is going to be pressuring, tormenting, intimidating, threatening, whatever you want to call it, that student. And that was the reason for this, amendment. And in addition, there are several things as well, is that because a lot of times too, we want to have this student to be able to be mature enough as well, and that's the reason for the member being put down here as either a junior or senior, and of course with a grade point average of 2.5. The other, which I didn't really put here, and I'll probably do that later on, because the law would not become effective until, I think is this for the new 9th graders coming in, that from there on, and all students then will be given service learning credits. And I wanted to say that in this case then, that this student, and maybe I really should do that, is to say that this child will receive service learning credit, which can actually be used when this child eventually graduates and moves on to college. So I see some nodding of the heads, and I'm scratching my head and wondering where am I going to put it, but maybe as we deliberate on this and someone would like to put it on while you're thinking about it as to where you want to put it, then I definitely would support that amendment. So that's the amendment that I that's the first one that I offer. I'm going to have to think of the language, though, and other duties, whatever as prescribed by law.
And we can come back to you,
Yes, thank
Speaker
you.
Wampat.
Thank
The amendment was passed out, the Wampat amendment was passed out. It has adding new section 2 and 3 to the bill to read. Do you guys all have a copy? Anyone wishing to speak on the motion? Speaker Pangilinan, you're recognized on the Wampat amendment.
Thank you very much, Madam Speaker. Madam Speaker, I rise, I guess there's just no way to say it except to say it. And I don't support stripping the voting right of the student. The whole system is about them. And when we finally put them on and give them a voice, if it's just for convenience, let's just add another member, another voting member. There's no harm in putting in another voting member of the public if we can preserve the voting right of that student. That's my opinion. And if we're doing it just for convenience because we don't want to add another member and make it 11, then I say that it's worth that inconvenience to protect the voice of the students, which is what the whole system's about, which is why we're all there, which is why we're here discussing this bill and trying to make it work for their benefit. And so I would support keeping their voice, and therefore I don't support the amendment of stripping the vote from the student.
Anyone else wishing to speak on the amendment? Okay, there was, I asked Speaker Wampat to close on her amendment.
Oh, okay. Yes, that, of course, is a very, touchy situation as well, and I understand where, my colleague is coming from. When you're going to do that, of course, and then you want to say that you want to increase it again to another member, there's always that question again, Madam Speaker, is that then do we want to increase then the number by an additional person then to have that odd number? Then who do you want to give that extra member to? Because there are two ways, knowing that this is a hybrid board. The governor gets to appoint until such time that we have the next election, and those are two members that will be elected. So now, if the discussion is to increase to another member because you want to be able to retain that voting right, then right now it's giving the governor again another member. Is that what we want? So to me, right now, I think the best thing is to proceed with the student member as a non-voting member, provide, of course, like I said, this the child will continue to participate fully. That does not mean that just because you don't vote, that means you can't participate, as a member, but as an added, benefit to being also a student member is, and I think someone wants to make that, amendment later about possibly getting this service learning credit. So, it's an iffy thing. I understand that. Depending on where we go, of course, would determine again whether there will be a need to go in and put in another amendment. But I guess for the time being, since there is one person who objects, you may want to call for the vote.
So there was an objection to the Wampat amendment, and I'm going to call for the vote right now. All those in favor of the Wampat amendment signify by raising your hand. The 1, 2, 3, 4, 5, 6, 7, 8. Motion carries. 1, 2, 3, 4, 5, 6. I got voted in. Speaker Wampat, you still have the floor.
I was so busy thinking, but I wanted maybe legal counsel can help me then with that, and that other language that's a very general language about, and any other duties as prescribed by law. Is that?
We're going to go ahead and take a 1-minute recess.
Thank you.
This legislature is back in session. I will recognize Senator Sam Mabini now for the main motion on Bill 32.
Thank you, Madam Chair, Madam Speaker. Well, first I rise to support the bill, but at this point, can I go ahead and add an amendment
Sure.
to the amendment that Speaker wants?
Do you have copies made, or is it?
I don't have any right now. It's just very simple, just adding a few
Okay,
words
go ahead and
afterwards.
state your amendment. And if
Sure.
it-
It's under Section 2C1, after the last sentence of Section number 1, the student member shall be a junior or senior at a public high school and maintain a grade point average of 2.5 or above, period. Student members shall receive service learning credits for their service hours on the board.
Okay, so read that in. Student service members shall receive
Service learning credits
service learning credits
for service hours on the board.
for service hours on the board. On that motion? No objection, motion carries. Senator Mabini, you still have the floor.
Yes, thank you. As I mentioned earlier, I am in full support of Bill number 3231, and I commend the author. Personally, having had worked with other boards who may have had some difficulty in defining their role between governance or policy making, I believe that this bill is extremely important. You know, we expect students and teachers and our administrators to be held by certain standards and to even be measured and evaluated by certain standards. This bill outlines at least a good number of activities that we expect of these leaders, and at least now we'd be able to go back and point out to some of the activities that we will help measure their performance as board members. Second of all, when I had served previously on the transition subcommittee on education, one thing that came out of those discussions with our education leaders from the various institutions was the immediate need to address how board members should be trained, should be informed, should be worked with to understand their specific roles when it comes to policymaking and governance. So this is the first step, I believe, to starting to address that one recommendation that came out of that subcommittee. And so I again commend my colleague from the village of Tamuning, and I again am in full support of Bill 3231. Thank you.
Thank you, Senator Mabini. Anyone else wishing to speak on the main motion on Bill 32? If not, Senator Yamashita, would you like to close or send it down?
Thank you, Madam Speaker, for your patience. First, I would like to ask or move, I'm not sure what the proper verb is, to have Madam Speaker as the second co-sponsor of this bill. That's okay. Okay. Thank you, Madam Speaker. As the discussion has evolved, Madam Speaker, we have identified another issue that needs to be addressed, and we're asking our legal counsels to help us out here. Madam Speaker has Speaker Wampat has come across a section about meetings of the board that addresses the quorum and the numbers needed to make quorum. It's subsection 3102.2. And it currently identifies 6 members, but as the motion had carried, the amendment had carried to have the student member being non-voting, we're thinking that that quorum is now 5. 5 members shall constitute a quorum. And 5 to take action. 5 is currently here, but we need to amend 6 to 5.
Senator Yamashita, can you please repeat that again? What page?
It's on subsection
Page.
30. You know, Speaker Wampat just handed this to me.
Okay. Is it section 3?
It'll be 10. Actually, it's actually reflected in the enabling legislation, Public Law 3183.
Okay.
And what we're saying is, as the amendment carried to make the student member a non-voting member,
Yes.
then the number of voting members now goes to 9. And so on page 2 of Public Law 3183, so the amendment needs to go from 6 to 5, yes. And that's what we're asking, is for an amendment.
Yeah, I'm going to, if you can go ahead and read it. No, I just wanted to know where the inclusion of that amendment, whereabouts that you wanted in.
Oh.
Page 3? Or did we want to have the legal counsel do technical?
If we can make it a new section 3.
This would be a new section 3, and then then the rest will go accordingly.
Yes.
Please proceed.
And so we think with that particular amendment, it will support all the other amendments that have evolved. And so with that, Madam Speaker, I appreciate all the reflection and the thoughts. I agree with Senator Pangilinan in the concern about saying that students...
Right. You have an amendment first, right?
Yes.
Yes. So you're speaking on that amendment first, right? Which is to add a new section 3, and can you read the amendment?
Yes. That meetings of the board shall be subject to the open government law of Guam. 5 members shall constitute a quorum.
Okay.
And that's the amendment. The law now says 6.
Okay.
It'll now
With
go to
that
5.
being said, so that we can save a tree, are there any objections? No objections. Motion carries. Senator Yamashita, make sure that that gets submitted to the clerk, okay?
Okay.
But you can do it after. Please
Okay.
proceed.
Okay. Thank you, Madam Speaker. And so, as I was saying, that I thank everyone for their reflection and their support and their additions and amendments to public law, to Bill 32. I started to say that I appreciate what Speaker Ben would, what the senator from Barragata was saying about the student and their voice. And as I spoke with the superintendent and with others about that particular idea about the student's voice, what the conversation focused upon is that there was concern about students having a vote on particular policies and wondering if they were at a maturity level to actually carry a vote on certain policies. And so as I thought more and more about that, that is something that I continue to grapple with, because I do believe that students, it is about all students. And so, but they are at the table, and that they will continue to remind us about what all our policies are about. So Bill number 32 then ensures that our board members know that their job is to oversee policy development and implementation, the evaluation of the superintendent, is to ensure that our policies are up to date, to ensure that all students are provided learning opportunities and prepared for life. And I think that as there was conversation about that fine line between policy and operations, I also agree the senator from Sinohania when he said that we can see that there are times when we just do it, and there are times when we know that we can say to somebody, you're really interfering. And seriously, the stories, the tales do go on about decisions being made outside of the superintendent's office, or decisions being made on behalf of certain school leaders. And it becomes very blurry about the protocol, and becomes very blurry about the hierarchy of the organization. So I ask for consideration. I ask for everyone's vote support for this. I do believe it'll strengthen the organization of our public school system, in that the lines would become a little less blurry, and that the accountability for our superintendent will be a bit clearer. And so with that, Madam Speaker, I thank you very much for your time.
Senator Yamashita. So on the motion, but did we want to move? We're going to go ahead and take a 1-minute recess.
Only take a few minutes, only a few minutes. Normally, okay, let me ask, I just want to ask this question because, okay, so the quorum now is 5.
Senator Yamashita, on the motion to move it down to the voting pile, are there any objections? No objections. Motion carries. To my colleagues, it's a little bit after 5 right now. We're going to go ahead and take a recess till 9 o'clock tomorrow morning, and I ask that everybody please be prompt. That's coming from the speaker. Thank you. We are in recess.